of the two ways that an ERISA disability carrier will use the results of a compulsory functional capacity evaluation to deny or terminate your disability insurance benefits, and how you can protect yourself. Did you know that most disability insurance policies will provide that you have to undergo a mandatory independent medical evaluation? But not all disability policies allow a disability carrier to have you undergo a compulsory functional capacity evaluation. A functional capacity evaluation can be a 4 to 6 hour or maybe even a 2-day evaluation of your physical tolerances, your ability to sit, stand, walk, stoop, bend, that sort of thing. And if you are a person who has ME/CFS, they might be looking for you to undergo a CPET examination. Now, rarely do they actually pay for that, but the concept here is the same. What they're trying to understand is what your restrictions and limitations are, notwithstanding what your doctor has to say. And I will tell you that these examinations, which are normally conducted by an occupational therapist, a physical therapist, or even a doctor, are not really designed to get at the truth of what your functional restrictions and limitations are. They are designed to create, if you will, restrictions and limitations that will allow the disability carrier to deny your claim. They'll also potentially give the disability carrier grounds for denying the claim on the basis that you didn't fully cooperate or give effort in the functional capacity evaluation. You have a contractual obligation under the terms of a policy to cooperate, and just the failure to do that can be a case killer. There are lots of games that the FCE provider will play because they're being paid a lot of money to say that you have the capacity to do your past work, or if we're at the any occupation stage, sedentary work. You need to be cognizant of what these games are, and I think that there are really two ways that the disability carrier will be using the results of that FCE to terminate your benefits. Now, as part of the FCE provider may have pushed you to do something that you can't really do. But to be cooperative, you're going to give full effort, just notwithstanding your pain. And the FCE provider is going to report that notwithstanding your pain, you did something at a higher level of functioning than was reported by your doctor. Number two, the FCE provider may turn it around and say that you didn't give full effort, particularly if you're complaining of pain or you want to stop or take a break. That can be problematic, again, because that can be a breach of your contractual obligation to cooperate. So how do you protect yourself? I think there are a couple ways. First, let's check the policy. Are you required to have an FCE? If not, say too bad, so sad. Now the carrier will probably set you for a not so independent IME. The second thing you might want to do is ask for the FCE to be videotaped. And if the carrier won't allow that, then bring a witness, like a nurse, to make a contemporaneous record of what happened during the FCE. You potentially, thirdly, could do a summary of what they did and do that at the conclusion of the FCE. But better yet, what I like to do is if my client has been scheduled for an FCE and they have to appear, I go get an FCE from my provider a couple days before their FCE because I want a true and accurate report of my client's restrictions and limitations. My FCE provider can take on that false manufactured carrier FCE opinion. If you have any questions about your rights to your ERISA disability benefits, if you've been scheduled for an IME or an FCE, it's time to call us at 727-894-3188 for a complimentary consultation. Don't let the disability carrier rob you of your disability benefits.